Good morning.
Morning, Your Honor.
Good morning.
Good morning.
Good
Okay,
morning.
I have just a few matters on my calendar this morning, so we're going to try and get through them as quickly as we can. Right now, I'm just going to get announcements to sort of figure out where we are, because I think I have two cases that will require a little bit of more time amongst me and the attorneys. Position one, who do I have here in the Arrest Georgia 2 versus Scott and Sons matter?
Ma'am, I'm Kushka Scott. Scott and Sons is a dormant LLC. I mean, it's been dissolved.
Okay. So forgive me, sir, I don't want to cut you off, but I'm happy to hear that substance part you're trying to tell me. But right now, I'm just trying to figure out who all's here and how long it'll take to get through the different things. So you've done what I needed you to do right now, Mr. Scott, was just to let me know that you are personally here.
And
And it looks like others may be here as well. Mr.
uh,
J. Scott?
yes, Jerome Scott, Your Honor.
Okay.
As well as Shield Scott.
Okay. Shield Scott. Thank you, sir. Sirs. And who do I have here on behalf of Rest Georgia 2?
Tyler Henderson. Got my colleague Rob Wheeler on the call too. We represent the Cato Company 2 Inc., which
Okay.
is the successor to Res Georgia 2.
Okay. And so I just needed to figure out who I was here. I'm going to get some announcements from everybody else. I'll be right back with you guys. Shine Investments versus the City of Atlanta. I see Mr. Henderson, or at least I did a second ago. There's Mr. Henderson.
Good morning, Your Honor.
Who do I have here on behalf of the City of Atlanta?
Good morning, Your Honor. Nicholas McDaniel here on behalf of the City of Atlanta.
Hi, Mr. McDaniel.
And Your Honor, Ms. Tuttle, I apologize for interrupting. Ms. Tuttle is also here on behalf of Shine
Oh, hi,
Investments.
Ms. Tuttle. How are you?
Hi, good morning, Your Honor.
Good morning. Okay. Thank you. And who do I have here on behalf of Bank of America versus Vincent Hale? It's kind of what I expected. I'll call it back again in a minute, see if anybody else joins us. Rebecca Humber versus Madeira Investments. Who do I have here in that matter?
Hi, good morning, Your Honor. Tyler Adams here on behalf of the Humbers.
Okay, and who do obviously I understand Madeira, this is a default matter, but had you been in any contact with Madeira? Did you have any expectation that anyone might appear here today?
No, Your Honor, I've not had any contact. I do not expect anyone to show up today, and it doesn't appear that anyone's here for them either.
Okay, thank you.
Thank you, Your Honor.
And Thornhill Association versus Andre Fluellen. Who do I have here on that matter?
Good morning, Your Honor. Craig Cooper on behalf of Thornhill HOA.
Hi, Mr. Cooper. And
Good morning.
same question. Obviously, I know that this is a default, but had you had any contact with Ms. Fluellen? Did you have any expectation that perhaps she might, or I'm sorry, Mr. possibly Fluellen, did you have any expectation that that person would appear?
No contact and no anticipation that they would be here today.
Okay, excellent. So I'm going to ask a couple of quick questions. I'm going to start with my two default matters that I just called at the very end because I know they will take 5 minutes. And we will go from there. Mr. Cooper, I'm going to ask you to go ahead and go first. I'll save you a little bit of trouble, which is I have reviewed the file, and my review indicates that you secured service on January the 22nd. That proof was timely filed, and so the answer was due on February the 21st. No answer was filed, and as of March the 10th, defendant Fluellen was in default without the ability to open as a matter of right. And so the only thing that I really need you to address for me that I've not had a chance to look at is any whether damages are liquidated or not, and what is the amount of those, I assume, unpaid assessments and attorney's fees that you are seeking.
That's correct, Your Honor. Thank you. I'd be happy to address that. The total that we're seeking today after calculated by fees for appearing this morning is a total of $7,407.97. The principal amount is $3,935, $136.35 of interest. Attorney's fees and cost of $3,086.60 and core cost of $250.02. And I'd be happy to testify as to the unliquidated attorney's fees.
That's all fine. Before you do though, I want to ask you a quick question. I'm looking at the proposed order that was sent in this matter. And it gives an additional attorney's fees for appearing at the hearing today of $350 for a different total amount of $7,757.97. Is that the correct amount?
That's the correct, yes, Your Honor.
Okay. Thank you. If you'll go ahead then, please.
Yes, thank you, Your Honor. My name is Craig Cooper. I'm an attorney authorized to practice law in the state of Georgia since 2013. And I'm associated with the firm in Nowak Howard. My hourly rate is senior associate for the firm per retainer client, such as Thornhill, is $350 per hour. Nowak Howard has performed legal services on behalf of Thornhill in the collection of unpaid assessments and related fees and charges from the defendant in this matter. On behalf of the association, our firm sent the defendant a notice of the debt and a demand letter, filed a lawsuit, perfected service, and prepared and filed the motion for default judgment and appeared before Your Honor at today's hearing. The legal service described, not including the fees for today's hearing, resulted in the expense of the association of $2,745 in legal fees, and then we're requesting an additional $350 for today's hearing, and $336.60 in expenses, plus $250.02 in court cost. And I have an itemized, Your Honor, I could screen share to show the itemized statement if you like.
That would be helpful. Yes, thank you.
This appears as Exhibit C in the exhibit list that we filed.
Yes, sir.
On the itemized attorney fee statement, all my fees and expenses in this matter are submitted as plain as Exhibit C, and in the full accounting, the amounts applied are shown in our Exhibit B, which is I have a outlined total here. These amounts are detailed in the attorney fee statement for this matter. The attorney fee statement is a business record for the firm, and it is in the regular course of business for the firm to make and keep such records. The entries appearing on the statement are made at or near the time they occurred, made by or from information transmitted by someone with personal knowledge and a business duty to report, and subsequently reviewed for accuracy. The hourly rates were performed, time spent, and total expense incurred for the legal services rendered in connection with this case are reasonable, usual, and customary in light of the nature and complexity of the work involved and are actually incurred by the association. And that's in your the total that's correct is the $7,757.97 what we're requesting.
Okay, thank you, Mr. Cooper. You can take down your screen share. Everything that you have presented both this morning and also in the filed papers that were in support of your motion do appear to be in order. As I indicated, the record is clear to me that Defendant Flewellen is in fact in default, and that the time for him to open default has passed, or as a matter of right has passed, and no effort has been made to otherwise open default. And so it does appear to me that your client Thornhill is entitled to a default judgment. The amounts that you have presented have been properly documented. And so I will enter the order that you have submitted. I'll probably change it a little bit because I typically spread the word. I like my default orders to specifically recite the date of service and then therefore the date the answer was due and the fact that 15 days have passed since then. So I'll add that in because I like for it to say it. And then other than that, we'll get it on file for that total judgment amount of $7,757.97. Anything else you need from me, Mr. Cooper?
No, Your Honor, I certainly appreciate it. And may I be excused?
Yes, sir. Thank you.
Thank you.
Have a good day.
You too.
Okay. Mr. Adams.
Yes, Your Honor.
Okay, so I'm again save you the same trouble, right? I've reviewed the file. It appears to me similarly that Madeira Investments was served on January the 22nd, and that the answer was therefore due on February the 21st. No answer was filed, and 15 days has passed since that time. I did have one quick question, which is just out of curiosity. not implying that the way that you got service was not proper because it is a statutorily allowable way to serve LLC. I was curious, why not just serve through substituted service on the Secretary of State?
Your Honor, it was in a way just mostly cost effective for the client.
Fair
It's
enough.
just the certified mailing, and again, as you said, it's allowed under the statute, and so we we end up just sending the certified mailing to the principal address as stated in the Secretary of State.
Yep, like I said, fair enough. And you have filed a proper affidavit confirming the inability to obtain service through more traditional means and then to satisfy the requirements of that statutory allowance for service on an LLC. So that's all fine. I have seen a good deal of filings in terms of your evidentiary support for the damages that are claimed. And so I have had an opportunity to review them. What I don't think I've seen, Mr. Adams, and if you've sent it, I apologize. Have you sent over a proposed order?
I have, Your Honor. I provided one. I believe it was, 2 days ago, actually.
Okay, and then I just
believe
haven't
it was
had a
on
chance to
Tuesday.
look at it
Tuesday.
yet. I will find it now and then ask you if you will make your presentation regarding the issue of damages and sort of as condensed and efficiently as you can. I would appreciate it. I do have a criminal jury trial that starts a little later this morning, so I got to get through you guys to get
understand.
to that one. So anyway,
I understand, and yeah, we don't have liquidated damages, so I do have to have some testimony from
absolutely
my
understand,
client.
which is I
But I will,
understood why we were
we will
getting
speed
that.
it. Yes, we will speed it along. So,
Mhm.
Rebecca, if you go ahead and turn on your camera and unmute yourself. And would you like
Okay.
me to just swear in my witness, Your Honor?
I will. Ms. Humber, are you going to testify first? Will you please raise your right hand?
Sure.
Do you swear that the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Thank you. Go ahead, Mr. Adams.
All right, Rebecca, go ahead and state your full name for the record.
Rebecca Lynn Umber.
And can you briefly describe the relationship that you had with Madera Investments doing business as Total Turf and Greens?
We hired Total Turf and Greens to do some landscape work for us in May, and we provided funds for him, which he required before the work would start. And then he required more funds 1 week before it started. We did both of those, which was in total half of the work. And he did not even start the work for another
All right,
month.
Rebecca, I'm gonna cut you off real quick.
sorry.
Just for efficiency's sake, and that's okay.
Okay.
We're gonna get to all of that, but so you're saying that you contracted for them to do some work on your property?
Yes, we contracted him to do some work on our property, and while he did some work, he didn't complete the work, and most of it caused damages.
And Rebecca, go ahead and take a look at the screen I'm sharing here as
Mhm.
Exhibit A. Do you recognize this document I've pulled up as Exhibit A?
I do.
Okay, is this the accurate depiction of the contract that you had with Total Turf and Greens?
It is.
And this contract's not signed, but was Total Turf performing work under it?
Yes, and we did provide a signed contract to Total Turf and Greens, but when I went to go try to pull that back up, we weren't able to use it because it was under DocuSign.
Okay, and what work was Total Turf supposed to do on your property under this contract? Just briefly.
Briefly, they were supposed to install artificial turf around our pool. They were supposed to provide a fire pit, including pavers, a retaining wall. They were also supposed to put in some trees for us, 20 trees, and walking paths on both sides of our property.
And did they do any of that work?
No, the only thing that they did was they provided some material that would go under the I guess turf.
Okay. Did they do it? And did they do any of that work properly?
No, they did not, and they provided the wrong material for that. And then they also damaged our pool decking along the way. We had previously installed a bamboo root barrier that they damaged as well.
Okay, and what's the total amount that you ended up paying to Total Turf? Do you remember that?
I believe it was 22,000 and change.
Okay, well, here to jog your memory a bit.
Yeah, thank
this
you.
This Exhibit B, and do you recognize these two documents here as Exhibit B?
I do, thank you.
Okay, and what are these documents?
Those are the two payments I provided to Total Turf and Greens before the work started.
And it was two payments of $11,000, $11,462.
Yes,
And by my math, that looks to be $22,924. Is that right?
yes, thank you.
And who did you end up hiring to finish this work?
We hired Forever Lawn. They were the turf company that needed to come in and finish that. And then also Genesis Landscape, who then provided all of the grading and things to prepare for the turf for Forever Lawn. They also put in the fire pit and a retaining wall and the walking paths for us. They also replaced our bamboo barrier that was broken and fixed our pool decking.
And so between these two companies, Forever Lawn and Genesis, did they just perform the same work that Total Turf was supposed to do in the first place?
They did, and replaced the damages. So they actually had to do more work.
And I have up here on my screen Exhibit C. Is this document, is this the invoice you received from Forever Lawn?
Yes, sir.
And what's the total amount listed here for the invoice? If you can read it.
$36,095.03.
And did you pay this invoice?
Yes, in full. Mhm.
And is this the invoice now for Genesis Outdoors?
Yes, sir.
And what was the amount of that invoice as well?
$32,206.25.
I think that's
That's
$208. Yeah, that's okay.
Sorry.
That's okay. It's small print. And
Yeah.
was this invoice paid as well?
Yes, sir.
Right. And then I'm going to go ahead and skip down here to Exhibit E. Do you recognize this document?
Yes,
Do you remember reviewing this document with me last week?
I do. Mhm.
Okay. And all these numbers here, can you just briefly explain to me what all these numbers here represent on this form?
Sure. The refund of unearned funds, that is what we've already paid to Total Turf. The next number is the interest on those funds that we had already paid. The overage is the next line, which is the differences that we had paid to the two other companies that we needed to hire to complete the work and repair the damages. And you see the subtotal, and then the next line is our attorney fees.
Right. Which I'll talk about attorney fees myself.
Mhm.
On the overages paid to contractors, is that number just the total number you paid to the new contractors beyond what you were supposed to pay to Total Turf?
Yes, it is.
Okay. And on the interest, did you calculate the end, or what rate did you use to calculate the interest? Do you remember?
I don't, I'm sorry.
Okay. Okay.
I
That's
think
fine.
we went over it and I cannot remember
fine.
that. I think it was 7%.
Okay. Right. So did you choose the legal rate of interest then?
Yes, the legal rate of interest.
Okay. And the time for that interest, is it for the time from the last time you paid Total Turf to today?
Yes, sir.
That sound right? Okay.
Mhm.
And so your total damages looks to read $52,504.90. Is that correct?
Correct.
All right. Those are all the questions I have for this witness, Your Honor.
Okay.
I have submitted an attorney's fees affidavit, but I'm also happy to go ahead and give my testimony here today, whichever the court prefers.
If you can do it, I have seen your affidavit, and I think I'm fine with just accepting it in terms of the work that you did, the hourly rate that you charge, and that is reasonable and customary based on your experience and the type of work that you do. And so, Mr. Adams, can you tell me, since I do have your order, I don't have it in front of me. So can you tell me the full amount of the liquidated damages sought by is it Humber? I don't want to.
Humbers.
Humber. It's
Humber. Okay. And then the additional amount, the total amount of the judgment sought, and then including your attorney's fees and their damages. $52,504.90.
Yes, Your Honor, that's the total amount of damages sought. Within that is the $5,868.25. That's attorney's fees and court costs.
Okay.
And then the the damages then sought outside of attorney's fees, that's the $46,636.65.
Okay, excellent. Thank you very much, Mr. Adams. I appreciate your efficiency. Ms. Humber, thank you for testifying. It's always, it's awkward for most people because it's not something you do every day. I think you did a fine job. Thank you for your time. Do you need anything? Mr. Adams, it appears to me, as I said to Mr. Cooper about his case, that in fact, the defendant in this case is in default and that you are entitled, your clients are entitled to a default judgment in this matter. And the evidence that you have provided properly supports the liquidated damages that are claimed. And so I am going to enter an order in your client's favor, a final default judgment in the amounts that you have sought. And so what I will do is find your proposed order that you have sent to me. And I will, as I said, insert the dates if they're not already there. And we'll get that on file for you probably today or tomorrow. Okay.
Yes, Your Honor. Thank you. And I will double check to make sure I sent it. I'm almost positive that I did. If I didn't, I'll make sure to get it to Mr. Freehoff immediately.
Okay, excellent. Thank you very much. You
Thank
both
you.
all may be excused. I appreciate your time.
Thank you, Your
Thank
Honor.
you,
Nice,
Your Honor.
nice seeing you again.
Bye. Have a good day. Good to
Thank
see you, Mr. Adams. Okay, let me go back now to position one. No, I'm going to go back to position two, Shine Investments. So Mr. Henderson and Mr. McDaniel. Here's my question. Supersedious motions are fairly standard. That it definitely is written in the directive. It says shall when it's asked for. The only wrinkle here is that the city of Atlanta, relying on the barge case, has asserted that because there is no money judgment that could be attached to a supersedious, that the court is not authorized to enter a supersedious. And so I was curious, Mr. Since I've had the benefit of the motion that Shine filed and also the motion that, or the response that City of Atlanta filed. What I don't have is if there, I wanted to give an opportunity to Mr. Henderson to respond, particularly because I did a little bit of research on my own and there were two things that I thought were interesting. One of them was the Gaslowitz case, and the other one was the reference in 5646 that nothing about the limitations in that statute limit the court's otherwise clear authority to, and I think it's in Title 15, to enter, to deal with supersedious. And so I didn't know if that was going to be your response or sort of, but I wanted to focus your efforts on that because obviously I'm very aware of the background. I'm aware that this case is pending in the Court of Appeals and that the only jurisdiction I have, and I don't want to touch any hot rail or any, anything that I'm not supposed to, is just to deal with this supersedious issue. So Mr. Henderson, I'll start with you.
Yes, Your Honor. And I think both points the court made are appropriate for consideration, but I want to start with the case the court and opposing counsel were relying on for the idea that we might not be able to have a supersedious here, which is the barge case. Even the language quoted in their response makes very clear that this is a case where it is appropriate to have a supersedious bond. The actual quote says, entry of a money judgment is an implied prerequisite to requiring a supersedious bond in cases involving only an award of money. And this is the important part, not highlighted in their brief, but the important part of the sentence, and involving no injunctive or other equitable relief. And this case does involve injunctive and equitable relief in the claims
Also involves
made.
property, which is why I wondered if the Gaslowitz case was instructive because it related to sort of a second level judgment and a charging order in a prior case. So
Yes, Your Honor. And I think both things sort of mediate in favor of having a supersedious in this case.
okay.
The case does involve injunctive relief. It does involve equitable relief requested in the original filings and in the claims that are maintained at this point. And so I think it is perfectly appropriate to have
Well,
supersedious bond in this case. And I think it's relatively easy to quantify what that bond could be.
Right. Let me ask you a question and then I'm going to throw it over to Mr. McDaniel. And that is, so there's two things that give me concern. One is saying there's injunctive relief here is maybe a stretch, right? I think if I recall, certainly there was injunctive relief requested, but my judgment actually denied the injunctive relief that was requested because the city had said, we're not going to tear anything down. And that the other property had already been torn down. So there was no reason for me to enjoin the city from tearing it down. So you're right. I did enter non-monetary relief in the sense that I entered a declaratory judgment on one of the counts that was requested. And so is that the part that you're talking about in terms of that there was a portion of the judgment was non-monetary in nature because it was a legal declaration, even if it wasn't traditionally injunctive in nature?
That's correct, Your Honor. And that claim is still, I mean, I understand that the city has consented to the issue, but the claim as it stands is still pending in the suit.
Okay. And then my second question, and this goes to your last point about the ability to quantify any such judgment or any such supersedious that I might enter. One part that gives me pause is even if I think that this is an appropriate case where there should be a supersedious, I think the city's point is well taken that because of the procedural posture of the case, the court doesn't have before it any evidence from which to make an informed declaration, or does it, from your perspective, about the amount of what the money judgment should, or excuse me, what the supersedious should be?
Yeah, I think that the court can look to the amount of damage that was done and the testimony that's been provided in the motion for summary judgment or the further evidence cited in the motion for summary judgment to reach that point. I mean, I think the court could, and if I had my druthers, the court would impose, the entire value of the destruction of the property. Now, I don't think the court will do that, but I certainly think that there's enough evidence in the record for the court to cite the quantifiable amounts that represent Shine's interest. And so even if the court were to select a lower amount, such as a bond representing the cost of having to deal with the appellate issue, or a bond having to represent the cost of some portion of fees to this point, I think there are plenty of ways to calculate it that are in the record and the court could rely on. But
okay,
I think you have pretty broad discretion here to do it, and sort of that.
Right.
And I apologize for interrupting, but I do think the point is correct that you have extremely broad discretion in granting a supersedis. And I think one of the things that should be considered when doing that is whether the appeal is dilatory or appears dilatory. Right. And this is a dilatory appeal. I mean, I just don't think there's any.
That sounds like one of those. That sounds like one of those hot things that I don't want to touch right now, Mr. Henderson.
Understood, Your Honor.
But I will say the other question that leads to, though, and there is some discussion of it. I think it's in the Gaslowitz case, but of the fact that. I take that back. It's not. It's in one of the other cases I looked at. But given that we're talking about the city of Atlanta, right, is the risk here to the entities, to your client? How? I mean, because typically the purpose of a supersedious requiring the posting of a bond is if there is a concern that if at the end of all this, right, you are successful in vindicating the rights of your client, that the defendant will not be able to satisfy the judgment. And I feel fairly confident that the city of Atlanta would be able to satisfy a judgment in the range of whatever we're talking about. So what of that issue, and how does it play into the court's exercise of its discretion as to a supersedious?
I think that absolutely is one of the areas, and probably the most common area, where a supersedious is granted, Your Honor. But it's not the limit of the court's authority, and the court is entitled to consider whether a party is using the appellate process to delay judgment and to delay payment. In essence, I mean, that's very clearly the strategy of the city here. They're trying to bleed Shine out. They have a clear liability case. They knocked down a building that they permitted. They destroyed everything in it. They caused millions of dollars worth of damage to my client. And now they just want the case to take as long as possible. It's why they've refused to comply with the mediation order of the court. It's why they've delayed doing discovery. It's why they haven't actually conducted any depositions in the case. This is a case where the strategy is just delay, 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 and let Shine bleed out. And I think the cases make very clear the court is entitled to consider that, entitled to consider the conduct of the parties thus far. And I think that the conduct of the parties so far, the court should look at it and say, listen, if you're really serious about this appeal, then you should be serious enough to post a substantial supersedis bond and proceed with it.
Okay.
I think
Fair enough.
it's a sign of seriousness, Your Honor, and one that I don't think that the city will actually post if this moves forward because the appeal, quite
Okay.
frankly, is frivolous.
Thank you, Mr. Henderson. Mr. McDaniel.
Good morning, Your Honor.
Good morning, sir. So I'm gonna set aside Mr. Henderson's. I understand his frustration regarding the position in which his clients find themselves on the end of this. You know, they feel as if they had succeeded in the trial court, and then now they've not been able to do anything with it because of the appeal. But I don't know that we have to get into that discussion. So I'd like for you to focus your response to me on because it seems that the city of Atlanta's clear argument is that I don't have the authority because there is no money judgment to enter a supersedious bond. And if I did have the authority to enter a supersedious bond, that I should not do so because there's no evidence in front of me as to the amount of any such bond. And if I've misunderstood the city's argument, tell me. But assuming that is the city's argument, if you could sort of focus your analysis on the stuff I've outlined in terms of my broader, more unfettered access under Chapter 15, which very clearly 5646 says is not limited by 5646, and the effect of cases like the Gaslowitz case and the fact that there is other non-monetary relief in this case.
Yeah, of course, Your Honor. And, I certainly the city takes issues with, some of the characterizations opposing counsel's made of the case, but I won't focus on that. Just a couple of points. Opposing counsel raised the issue of, there being an injunctive relief still in this case. And while, the claims are brought, as you said, focusing on this summary judgment order, which is what's brought us to the appeal, the injunctive relief was denied. All you have is a declaratory judgment, and otherwise a judgment as to liability, as to inverse combination. There's no, disposition of property. There's no equitable relief, providing relief to Shine under the order. It's simply just the declaration and then a liability judgment as to inverse condemnation. So, I think saying it involves equitable relief, for purposes of adjusting the barge case is a stretch, and I don't think that's what was intended by the court in that order. When it comes to, the barge case and just in general, the amount of damages before the court, it's just simply not there. There are a few minute amounts that were referenced in Shine's summary judgment briefing. It does not nearly address all the categories of damages that Shine has asked for, which included, I think, lost rental income, property damage, construction costs, several categories of damage. There's been no, comprehensive evidence presented on that. The city's had no chance to rebut that. The only reason this order, I won't say the only reason, but, we got to this point with this order being entered partly because the city had not had a chance to respond to it due to a dispute over service, which is something we're addressing on the appeal. But, that the opposing counsel says to look to the testimony in the summary judgment briefing and says that the evidence is there. But, if you look at Shine's summary judgment briefing.
Let me save you the trouble, right? So the reason I am aware that information is there, but the court did not make a final ruling, did not address the damages, right? What the court said was that Shine is entitled to relief because of the inverse condemnation claim and the declaratory judgment ruling, but that the court needed to have a hearing on the issue of damages.
Right.
And so I understand that none of those are proven. But Mr. Henderson's point is that at least there is some evidence in the record of what they claim their damages to be in terms of what they believe they could offer evidence to show. And I will say this, without having a whole lot of specific documentary evidence, disputed or undisputed facts, I mean, it was a whole building that got knocked to the ground. So it's not that hard to say there's clearly some monetary value there. I think you're right, though, that I don't necessarily have facts before me that would make definitive the amount of such, loss.
And I think the point, Your Honor, is not that there's, no potential monetary value there, but it's that, there's not testimony or evidence of the damages. The point of the supersedious bond is to prevent execution upon a judgment and protect that money while on appeal. The evidence is simply not here. And, as Your Honor mentioned before, the risk here also of the city of Atlanta not being able to to pay that amount for this single property is not a factor in this case. Any characterizations about why opposing counsel thinks the city's appealing are not relevant to this analysis. At the end of the day, the point of the supersedious bond is to prevent execution upon a specific money judgment and to protect that money for the purposes of appeal. And not only is there not a specific money judgment, there's not anything near sufficient evidence to calculate all these various categories of damages they're seeking, and there's no risk of the city not being able to deal with this amount. So under these current circumstances, I don't believe that there's any real clear path for the court to appropriately issue a supersedious bond in this time.
Okay. Thank you, Mr. McDaniel.
Can I respond briefly, Your Honor?
Very briefly, Mr. Henderson.
I'll be very briefly, Your Honor. I just have a couple points. As to the point that the court was discussing regarding the entire building being destroyed and damages, the case law doesn't suggest that you have to have a specific amount, that you have to be able to prove damages with specificity to order a supersedious bond.
Well, no, but I
You
mean,
just have to
the
have something to
city,
base it on.
well, right, but the city's argument is that part of the support for their argument that you shouldn't enter a supersedious when there's not a money judgment is that when there's a money judgment, the only speculation I have to engage in is typically to add some additional amounts for the cost of delay and attorney's fees, et cetera, associated with the time of the appeal. And I don't have that here. Mr. Henderson, you've unmuted yourself. I'm sorry, Tyler Henderson, you've unmuted yourself. Sorry. And so I just wanted to get us back to that, right? So it's not that I just always hesitate when I don't have, I think he's right to point to the fact that I don't have a money judgment here to anchor the amount of any bond that I would enter.
But you do have undisputed evidence of the amount of the investment in the property that was completely destroyed. So an investment that was rendered completely useless. So,
well, only
it's much more-
undisputed, only currently undisputed because the city decided, which was their right, to file an appeal instead of go to a damages hearing and offer evidence that disputed the evidence that you had offered regarding the amount of the value of the building.
And I think that really gets to the heart of the second point I wanted to make, Your Honor, is that the hearing has been delayed. So what the city is in essence arguing is that supersedious can be prevented wholesale if they just get the appeal in before there's a damages hearing. So there's just no way to have a supersedious under the city's model if you're litigating properly on the other side of it. And I certainly don't think that's the intent of the statute to say, got it in time before you had the damages hearing. Now there's no evidence of damages because we appealed before the hearing. I mean, I think that's a little bit ridiculous to suggest. The last point I want to make, Your Honor, and this is, I think, probably the most important, is that the injunctive relief is not the only equitable claim in the case. There's also the declaratory judgment claims. And as the court knows, declaratory judgment actions sound in equity. And that is one of the more substantial claims still remaining in the case. So I think we meet the requirement for supersedious on all fronts here. I think there's evidence to which Your Honor can calculate damages. I'm happy to submit a secondary brief on the issue for what we believe the calculation could be based on or how we would calculate it if the court would like that. But beyond that, we have claims that don't sound purely in monetary damages. We certainly have broad authority of the court to make the decision. And I just think on all fronts, we've hit this one and should have a supersedious in place.
Okay. So as I started from the beginning, I think that the barge case is not the end of the answer and that there's at least some additional authority under, as I said, I wish I could call it to mind and I didn't take notes very well, but the chapter 50 in 5646, I think it's subparagraph E specifically says that nothing about 5646 limits the authority that the court has under chapter 15, which governs that particular statute that I can't call the rest of the chapter and section for, the authority of judges to control supersedious. I also think that the Gaslowitz case, which is 770 Southeast 2nd 245, provides the court with some that provides me with some reassurance that it would not be wholly inappropriate, particularly because Gaslowitz is in the context of building and land damages that are attached to property loss, which is what's happened here in the larger sense. And so I am persuaded that I have the authority and that it would not be wrong or error for me to enter, to require the posting of a supersedeas bond. Mr. Henderson, can you tell me the amount, if you, what the amount of the bond that you believe is appropriate for the court to require to be posted?
The top of my head, Your Honor, I'm not sure that I can give you that number, but I can certainly send it via email very shortly.
Okay, and well, that's fine, because what I was going to ask is, Mr. McDaniel, obviously your position on behalf of your client has been that I should not grant a supersedeas. But if my ruling is going to be that I am going to require the posting of a supersedeas bond, given the dispute, the fact that there is not a money judgment that allows me, that I can anchor any amount to, I do not want a whole big long brief from either of you. I want a very straightforward, because this is not something you're going to find an answer to in case law, in terms of the amount. But I would like both of you to let me know, Mr. McDaniel, this is what I do to the DA's office all the time when I say, I know you don't want me to grant bond, but if I grant bond, do you have an opinion about how much it should be? And this is a pretty apt comparison here. I know that you don't want me to require the city to post a supersedeas bond. I think I'm going to require a supersedeas bond, but truthfully, I'm going to be fairly conservative in the amount of the bond that I enter, because I don't have a money judgment to tie it to. And so if today or tomorrow, today's Thursday, by tomorrow close of business, if the two of you can email Mr. Freehoff and let me know what your opinions are about what you believe would be a reasonable supersedeas bond under the circumstances. Again, understanding that I am making the decision that I am going to require the city to post a supersedeas bond. The question that we are still left with is the amount. And Mr. McDaniel, if on behalf of your clients, the city wants you to take the position that the answer should be zero, I'm not going to hold that against you. That's a fair statement. I'm not going to like the answer. It's not going to be helpful to me, but I understand your client's position. And if that's the answer you have to give, that's the answer you have to give. But I would appreciate some insight if the city of Atlanta is willing to give it regarding if they're forced to post a bond, what would be reasonable under the circumstances.
So, Your Honor, I would ask, would the city have a chance to have, 24 to 48 hours to respond to opposing counsel's brief once it's filed? I mean, as he stated.
Well, I've just told him I don't want a brief. I want an email. And so I just want an email from Mr. Henderson saying what he believes would be the appropriate amount. And again, Mr. Henderson, I've got the benefit of the summary judgment briefing. I don't want you to recite the entire damages portion of it. I just want something that you believe is a reasonable amount. And then, yes, Mr. McDaniel, if you would prefer to have, I feel like that the larger answer is already in that briefing, because I think Mr. Henderson's original ask was like $2.5 million or 2-point-something million ish, associated with the loss of the building and then some damages for loss of time and attorney's fees. And I'm expecting that that's not what I'm going to get from him now, because I've very clearly said if I'm going to enter a bond, it's going to be a conservative bond. Not the sun, moon, and stars, because I've made no findings on damages. And so if you would rather have it be a responsive opportunity, then what I'll do is I'll have Mr. Henderson, if it's not unreasonable, provide me with their ask by today at 5 p.m. and then require the city to respond by tomorrow at 5 p.m. And that way you would at least have the benefit of knowing what he's asking for before you are forming a response.
I would appreciate that.
And Your Honor, I just don't have the exact number in front of me, but for Mr. McDaniel's benefit, I can tell the court the amount that or the factor that causes the amount we're going to ask for, which would be the unpaid amount of the mortgage on the property at the time it was destroyed. I think that is a very appropriate conservative measurement of bond. It's objective. We know the exact number, and so we can transmit that to the court. I know it's, I believe off the top of my head, it's a little over $500,000. But we'll get you the exact number just in an email saying here's why we're asking for it and here's what the number is.
Okay, excellent. I understand. And Mr. McDaniel, so the outcome here today is, as I've said, I am going to require that the city post a bond. The only issue left open is what will be the amount of that bond. And Mr. Henderson is going to provide me by 5 p.m. today the justification for the bond sought. And then Mr. McDaniel, you on the city, on behalf of the city of Atlanta, can provide me with a response to that by 5 p.m. tomorrow, okay?
Yes, Your Honor.
And that will be by email to my staff attorney, Mr. Freehoff, okay?
Yes, Your Honor.
Thank you both. I appreciate your time.
Thank you very much, Your Honor. Can we be excused at this point?
Yes, you may. Thank you.
Thank you, Your Honor.
Okay, Mr. Wheeler, Mr. Henderson, I apologize. And Mr. Scott, I apologize for keeping you waiting as long as I have, but I do appreciate your patience. Much like what I just did with the other attorneys, I've had a chance to look at the materials that were submitted by the defendants in this case. Now, I don't know. I'm going to need a little guidance from Mr. Wheeler or Mr. Henderson. But here's ultimately my question. As I understand, so where we are now is there was previously a judgment. It was in place for a number of years and it needed to be renewed because it had become dormant by passage of time. And the assignee that Mr. Henderson and Mr. Wheeler represent filed this post-judgment action seeking to renew that dormant writ of scire fasciis, which I'm sure I did not pronounce correctly, but who knows how to pronounce that word? It's too old. In any event, the response that I've seen, I'm assuming because all three, or excuse me, it looks like 1, 2, 3, 4 entities are named, that they were either corporate entities, resulting corporate, like inherited corporate entities, and then individual principals who perhaps signed some sort of personal guarantee or something like that. But I'm assuming, because all 4 of them are named, that the original judgment was against all 4 of them in some form. And then the response that I've gotten is that there was a bankruptcy. And the position I understand of the defendants is that bankruptcy operates as a bar to the assignees' efforts to continue to maintain or revive that dormant judgment. So here's my question. Number one, who was the actual bankrupting party? Because that would matter, right? Because if it was just, say, one of the individuals, then that might be an issue we need to discuss. But also, my question is, was this... So my general understanding, very general, never practiced bankruptcy law, but my general understanding is that debts have to be listed in order to be liquidated, although there can be circumstances where more broadly debt is liquidated if a creditor is notified of an issue and fails to assert its right. But I guess all of that is a long way of saying this. The briefing that was submitted legally, factually by the defendants to whomever that bankruptcy applies, it isn't wrong in the sense that if this was a listed debt as to one or all of the defendants, then it is possibly a bar to this effort. But I don't have enough information about the bankruptcy because I don't have access to PACER to figure out which defendant or defendants the bankruptcy applied to and whether or not this was a listed debt that would have operated to liquidate or bar a future effort by these assignees to recover. Mr. Henderson or Mr. Wheeler, who am I going to hear from first?
You'll hear from me, and
Okay.
Your Honor, I'm sorry that you're having to deal with yet another Mr. Henderson this morning. So I'll start there. You've got all of this right. The judgment was obtained by one of these Rialto entities. I'm sure the court has seen a bunch of them. I don't know if any still exist. They assigned the debts here and there. My client, the Cato Company, ended up with this one. So just to be absolutely clear and make sure we don't run afoul of the discharge injunction, we are not trying to revive the judgment against defendant Shields Scott. He received a discharge in July of 2016. So today, we're only proceeding against Scott & Sons Holdings, LLC, Koshka Scott, and S2 LLC, which was formerly known as Scott & Sons Holdings, LLC Limited. There's another case, a related case, where we're pursuing revival against Jerome Scott, but
But that's not this case
That's
today.
not today, correct.
Okay.
So the central issue Your Honor raised is who was the bankruptcy debtor and what happened in that case. If I may share my screen.
Yes, sir.
Let's see here. This is the exhibits to our petition were exhibits A, B, and C. So this will be exhibit 1. And this is an order signed by Judge Bezier, Northern District of Georgia Bankruptcy Court in September 2018. And here, Res Georgia 2's immediate successor in interest, NCP Bayou 2, tried to block Mr. Koshka Scott's discharge in his bankruptcy case. Our predecessor moved for summary judgment and the court granted it. It's a long order. I can email it to Your Honor, but at the end, the court says, for the reasons set forth above, we're granting summary judgment and the debtor's discharge is denied pursuant to 11 USC 727A3 and A4.
So let me stop and ask you a question. Again, never practiced bankruptcy law.
Sure.
So is this motion, which I am going to ask you to send me so I can review, or this order, I should say, when it says the debtor's discharge in this case is denied, is that a writ large denial of the entirety of discharge from a bankruptcy, or as to a particular debt that is the subject of this adversary proceeding?
So there is denial of discharge, which denies the debtor the fresh start they go into bankruptcy looking for. Right?
Okay.
Where all debts, for the most part, are wiped clean, you get a fresh start. Then there's an objection to the dischargeability of certain debts. The first one is under 727. That applies to all debts. The second is under 523. That's specific debts here and there. Judge Bezier said that the debtor's discharge was denied under 2 subsections: failure to maintain records, or not adequately explaining losses. Essentially, you didn't come into bankruptcy court with clean hands. So what does all this mean? The 11th Circuit, can you see this case, Your Honor?
Yes, I can.
This is In Re Piazza, a 2013 case in front of the 11th Circuit. It was 719 F 3rd 1253. And the court explains here that under section 523A10, denial of discharge under 727A2 through 6, and again here we were 3 and 4, precludes a debtor from discharging any debt that was or could have been listed or scheduled in the prior case. That's great. It kind of makes my head hurt, but then there's a second case here. It's from a different district. This is In Re Hang, 589 BR 234. It was a District of Rhode Island case. And court says the same thing here in the yellow highlight about the permanency of a discharge denial. Down here, this is what sends the message home. The denial of a discharge under any of the enumerated subsections in 523A10, which includes 727A3 and 4, renders debts in a prior case permanently and automatically non-dischargeable. So my understanding of what happened here is Mr. Koshka Scott, filed this bankruptcy case in 2017. The order wasn't entered until a year later, and his discharge was denied. I think he cites a subsequent case. So he filed another case at some point down the road, and the bankruptcy court entered a discharge in that case. All that I did was discharge any debts that arose after the entry of this summary judgment order and the entry of the denial in the second case. So since our judgment was a 2015 judgment, it wasn't wiped out. It wasn't at all affected by his second bankruptcy case. And again, I will email all of these things to the court, but that's where we stand here. You know, he's asserted a time-barred argument. I don't really understand that. We are not yet even 10 years from the entry of the judgment itself, let alone the recording of the FIFA. And then they say we didn't include any evidence, any written evidence showing that our client, the Cato Company, is entitled to enforce this judgment now. We attached the assignments to our petition. And it shows a complete chain of assignment going from Res Georgia 2 to NCP Bayou 2.
Right. Well, I'll save you the trouble there, Mr. Henderson. That's why I started with the bankruptcy questions, because I agree with you that the other bases asserted, I do not believe are legally accurate, that the statute of limitations is not applicable in this context. The time for a judgment, you are correct, has not yet run. As you said, we're only in less than 10 years. The real issue that I was interested in hearing about, and I think you have addressed it, is the bankruptcy issue, which is the first two issues that the defendant raises. The second one, again, being one that I don't believe is something that is legally accurate, which is that this court is somehow deprived of jurisdiction to concern a properly secured, recorded, etc., non-discharged in bankruptcy debt. And so the issue for me really was and is this issue of its status as to bankruptcy. And so I'm going to ask you a couple more questions just to make sure I have the lay of the land, and then I'm going to call on Kashka Scott, if to the extent or he wants to respond. So as I think I understood you to say, Mr. Henderson, your client is not seeking recovery against Shield Scott because he did in fact have a discharge of this debt at a prior time, and therefore you are not seeking relief or the revival of the judgment to enforce against Shield Scott. Is that correct?
Absolutely correct.
Okay. And then Kashka Scott, for all the reasons that you just outlined, you are seeking to continue to enforce the judgment against him. Is that correct?
That's correct.
Okay. And then what of the Scott and Sons Holdings and the S2 LLC? I understand that those are dormant, defunct LLCs, but is there anything barring your continued effort to enforce the judgment against those entities to your understanding? Everything I saw, and that's why I asked who the debtors were in the response that was filed, was it was unclear that the debtor was anyone other than an individual. And so I assume that you believe, despite the fact that they're likely defunct and non-funded and have no recoverable assets, right, that you're still entitled to try and recover from Scott and Sons Holdings LLC and S2 LLC. Is that right?
That's correct. Yeah, it may be a poor financial decision, but I don't think that's part of the statutory analysis. And I think one of them is active. And
Okay.
I want to say one more thing. Mr. Scott argued that this isn't for your honor to decide. This is an issue for determination by the bankruptcy court. I practiced there a lot. My former firm was mainly debtors attorneys, so spent a lot of time in bankruptcy court. And if we were to go back to Judge Bezier, he's going to say, "What the heck are you doing here, Mr. Henderson? I've already made my determination. This is a state court issue now. You need to go back to Superior Court. My order is very clear. What more do you want me to say? I would be entering an order saying what I've already said." So this is something your honor can decide.
Okay. Thank you, Mr. Henderson. Mr. Kashka Scott, and let me just say, Mr. Jerome Scott, other than to the extent that you are a principal of one of these businesses that is no longer in practice, operation, what's been represented to me by the creditor here is that there is a separate matter involving you, and that matter is not before me today. So if I don't call on you today, that's why. I just want you to know I'm not deliberately ignoring you, sir. Okay.
Okay.
Thank you. Mr.
Thank you.
Mr. Shield Scott, you are welcome to remain and observe because I'm sure it concerns you. It seems like, given the last name, that's probably a family. But just to let you know, you did hear the creditor here say that they are not attempting to enforce this judgment or revive it as to you because of the prior bankruptcy discharge. So just so you know, you have heard me say that. You have heard them say that. Okay, sir?
Can I ask a question?
You may.
For my father, do you know when his matter will be before you?
I do not. And I honestly don't even know. It may get assigned to me as a related case, but I don't even know if it will be assigned to me. I can tell you if the case is already filed and it is not assigned to me, Mr. Henderson, if y'all want to look and see if it qualifies as a related case, it'll save another judge having to figure this all since I've already been educated as to that topic. So just you might want to check on it. And if you do have that information that you could share with Mr. Jerome Scott, that would certainly, in terms of where the case is procedurally, that would probably be helpful to him.
I have that, and we'll, I'm pulling it up now. I'll give it to you in just a moment, but I'll let Your Honor discuss
Thank
with
you.
Kashka Scott.
Okay, Mr. Kashka Scott. So I just want to tell you, as I think you heard me say, the main thing I want to focus on is this issue of, because I've read your brief, as I've said, there were a number of reasons that you gave, and the one I was primarily interested in was this issue of whether or not this debt had been discharged in bankruptcy. And so I would like for you to focus your remarks on that topic. And now is your opportunity to address the court if you'd like to, sir.
Okay. Yes. I refiled bankruptcy in 2023. Res GA was notified. It was discharged. Even in after, and let me back up before the first when they filed the adversary proceeding and the debt was not confirmed or not to be non-dischargeable. I filed a brief with Judge Bassier. We had a hearing, and he ruled then that this debt was non-collectible. I don't have that document, but I can get that document to you because of lack of assets, basically.
Okay, but non-recoverable isn't the same as dischargeable, right? So
yeah.
It may be, as a practical matter, that no one will ever be able to recover, but that's not the same as a court saying no one is allowed to try to recover.
And I understand that, but that's why I think this is a matter for that they should be taking this up with bankruptcy court as opposed to state court, because this was this was approved and signed by Judge Bassier at the time when they were trying after they got the judgment for non-dischargeability.
Understood. Okay.
And I think Judge Bassier will have something to say about that. Just like unlike what the defendant's attorney was saying, I think he would be able, we would be able to present that to him and make our case why this shit that's still the situation.
Okay. Mr. Henderson, can you answer one quick question for me? To Mr. Scott's point, the attachments that he submitted were about a 22 filing and a 23 discharge. And what you were showing me was about a 2017 non-discharge. I think I understand, correct me if I'm wrong, that your point is once it was deemed non-dischargeable in 2018, that no other subsequent bankruptcy could result in a discharge of that debt. Is that what I understood your legal argument to be?
That's right. And the bankruptcy code is not super easy to understand. I think it's better as a sleep aid. And that's what the Hang decision explains, is that the creditor doesn't have to go through this exercise if the debtor files case after case. The denial of discharge is automatic and permanent. Okay.
So, Mr. Scott, I appreciate your concerns. I appreciate your briefing. I understand your concerns specifically as it relates to bankruptcy court. But at the end of the day, bankruptcy court and the superior courts of the various states, or whatever kind of court we're going to call them, they interact because judgments to be enforced are creatures of state law. And ultimately, if a federal bankruptcy court wants to determine that a state law judgment is not enforceable or is dischargeable or non-recoverable, that's within their purview. But it's within my purview whether a judgment is properly recorded and whether it is legally authorized to be revived and therefore continue to be enforced. And having read your opposition and having heard the information that you have presented, it may be that you might want to go have another conversation with the bankruptcy judge about the effort to enforce the judgment. But my issue is not about enforceability. My issue is about the existence and rightness of that judgment. And in reviewing the record, it appears to me that Res Georgia 2 LLC has done what is legally necessary and provided an appropriate legal showing to demonstrate that the judgment as to Scott and Sons Holding LLC, the judgment as to F2 LLC, and the judgment as to Koshka Scott are appropriately renewed or revived, as the proper legal terminology may be. And so again, if there's an effort to enforce it, then you might be right that that might be an issue relative to the bankruptcy court, but its existence and its continued legal right to exist is within my purview, and I believe that the plaintiff has made the necessary showing. Mr. Henderson, will you please provide me with a proposed, I'm sure you probably already have and I just haven't seen it, but if you can provide me with a proposed order, that would be helpful.
Mr. Koshka Scott, can I get your email? I didn't see it on the document you filed, but I'll copy you on my email to the court with a proposed order.
I think I sent you a courtesy copy. But
yeah, that's true. Okay, I should have your email.
Your Honor, I did have one question.
Yes, sir.
One of the defenses was, lack of assets. I mean, I have no assets from the 2023 bankruptcy, and nothing has changed since then. I think that this is like beating a dead horse at this point.
I understand that, Mr. Scott, and sadly, I see lots of people in your position, and I am sorry. But as I said a moment ago, the ability to pay a judgment has legally nothing to do with the legal right of a creditor to get that judgment. They may never be able to enforce it or recover it or satisfy it, but that doesn't mean they're not legally entitled to have the judgment.
Okay, so I'm sorry.
No, go ahead.
So that's not a defense to the denying the reviving the debt, is that there's no ability to, okay.
Not to my knowledge, sir.
Okay, thank you very much.
Thank you, sir.
Mr. Scott, I was going to say, for Mr. Jerome Scott, the hearing is before Your Honor. It's on April 24th at 9 a.m. I believe the same Zoom.
Okay.
What day was that?
Sorry, can you repeat that date?
Can you repeat that? I didn't hear it.
Yes, sir.
Yes, sir. April the 24th, he said. And my hearings are always at 9 a.m. And it will be just like this. It will be a Zoom link that you will have received. It'll be in the notice that went out. And that will be for Mr. Jerome Scott.
Could I ask the question, Your Honor?
Yes, sir.
So, is there any paperwork on that case? The only paperwork I've received is on this case.
So if you have an email address, or if one of your sons, if they want to give me an email address, then I'm sure Mr. Henderson can make sure that you've received notice. We typically, if someone does not have an email address, we will physically mail it to a person. And our notices of hearing, which should have gone out, if it's scheduled for the 24th, it may not have gone out yet, but it's typically a lengthy document that includes the Zoom link. And so, Mr. Scott, if you have an email address, or if you want to give me one of your son's email addresses, and you can email Mr. Freehoff, who's on the screen, just if you can see how his name is spelled. His email address is mitchell.freehoff@fultoncountyga.gov. And if one of you will email him, then he will make sure that he will respond and email you and provide you with a copy of the notice of hearing, which contains the Zoom link.
I've just changed my name to my email address, if it helps.
Excellent. Okay.
I have one other question.
One more question.
Yes, sir, Mr. Scott.
So I don't have to be served again for a different case?
So yes, you always have to be served. I don't know anything about, you have to get notice. But
I haven't. Okay.
But that case isn't before me right now. I've not looked at it. I don't know anything about the circumstances, sir. And so I can't address that. Those are substantive issues we would take up at the hearing if you're going to argue that you didn't receive proper notice.
I haven't.
So, but again, that will be for that day. Okay, sir?
Okay, thank you.
Okay. Mr. Koshka Scott, last thing.
As concerning the dormant or the defunct LLCs, are your ruling just for me, or?
No, sir. As I said, when I announced what my ruling was going to be, it is as to Scott and Sons Holding, S2 LLC, and Koshka Scott. That's okay. That judgment continues.
Okay, and I'm not responsible for answering for those, the LLCs, correct? I'm just, since they're not in effect.
Well, let me say this. Legally, an individual cannot represent an LLC in Superior Court. They have to be represented by counsel. And so I don't know if you're responsible in the larger sense, but legally, if you're not an attorney, you're not allowed to represent those entities.
Understood.
Okay. Mr. Henderson, you're going to email Mr. Freehoff the proposed order that you want entered. Someone of the Mr. Scotts are going to send Mr. Freehoff an email address, and Mr. Jerome Scott will ensure that you have the information that you need for that April 24th hearing. Okay.